Welcome to the deep dive. Today we're tackling a really classic legal puzzle. It's all about survival versus property rights.
Right.
And it hinges on one big question. If you're in an emergency and you have to use or maybe even damage someone else's private property to save your own skin or maybe your boat, are you legally on the hook for that damage?
That's the core of the necessity defense. And it's fascinating in tort law because the law has this tough job, right? Deciding which of two innocent parties has to bear the cost when disaster strikes.
Okay.
So we're going to really dig into the court materials here, focusing on a landmark case from 1910, Vincent v. Lake Erie Transpotco. It pretty much set the standard.
Vincent, right. Got it.
Our goal today isn't just to state the rule, but to really get under the hood, understand the policy behind it. We'll define the two flavors of necessity, public and private.
Okay.
Then we'll break down Vincent using that structured FIRAC method, point by point. We'll look at why the court said the injury was, quote, controllable, and then wrap it all up with a practical checklist, something you can actually use to spot these issues.
Excellent. Sounds like a solid plan.
Yeah.
Let's start with the basics then. What's the main legal rule here, the one that creates this defense?
Yeah.
And you mentioned two categories.
Yeah, exactly. So the general rule is pretty broad. Necessity gives you a privilege to do something that would normally be a tort, like trespass or conversion, maybe even battery in some extreme cases.
A privilege, okay.
But only when that action is reasonably needed to avoid a much bigger harm. This privilege means the act itself isn't legally wrongful or criminal. But, and this is key, the consequences, especially who pays, hinge entirely on who gets the benefit from that necessary act.
Ah, okay. So that leads us to the two types. You mentioned public and private necessity. Let's start with public. When does that come into play and what happens then?
Right. Public necessity, that's when you interfere with private property, but you're doing it to protect the community, the public as a whole.
Okay, like a common good situation.
Exactly. Think of a firefighter tearing down a house to stop a wildfire spreading through a town, or maybe seizing supplies during a flood. The benefit is widespread.
So the individual property owner loses out for the greater good.
In a sense, yes. Because the benefit is public, the law usually treats this as an absolute privilege. That means the person taking the action, the firefighter in our example, generally doesn't have to pay compensation. The loss might just fall on the property owner, or maybe the government compensates through some other channel, like a statute.
Got it. Absolute privilege for public good. Now, the flip side, private necessity. This is where Vincent fits in, right?
Yeah.
What's the crucial difference here?
Precisely. Private necessity is when you interfere with property, but it's only to protect your own stuff, your own life, your own property.
Like the ship in Vincent.
Exactly like the ship. And here's the critical distinction. Private necessity gives you only a limited privilege. You get to do the actor to the back. You're not considered a trespasser for staying tied to the dock, for instance. But you still have a strict legal duty. You must compensate the property owner for any damage you cause while you're exercising that privilege.
So in Vincent, the ship owner was acting purely to save his own ship, which was worth way more than the dock damage. That puts it squarely in private necessity.
Dead center.
Which means they had the right to stay tied up, but they had to foot the bill for the repairs.
That's exactly right. They saved their private asset, not the public harbor of Duluth. And that policy choice, the idea that the actor pays, is precisely what the Vincent court was wrestling with.
Okay, let's really zoom in on the case now, see this rule working. Let's analyze Vincent v. Lake Erie Transport Company. First, what are the legally dispositive facts?
Okay, the facts really set the scene. It's November 1905. The defendant's steamship, the Reynolds, is tied up at the plaintiff's dock in Duluth, Minnesota. It's just finished unloading cargo.
Standard procedure so far.
Right, but then, a massive storm blows up on Lake Superior, unexpectedly violent. Winds hitting gale force, maybe 50 miles per hour or more. Navigation basically shuts down. The crew finishes unloading, signals for a tugboat.
And none could get there.
Exactly. Too dangerous. So the ship's stuck. The crew knows if they cut the lines, the ship's probably doomed. It'll get smashed against rocks or just sink.
So saving the ship, which was obviously worth a lot more than the dock, was the priority.
Absolutely. So what do? They keep the mooring lines fastened. And not just that, as the lines start to fray or snap under the strain,
they replace them.
They keep replacing them. They actively, deliberately keep the ship pressed against the dock. The storm keeps lifting the ship and slamming it down onto the dock structure.
Ouch.
Yeah. End result. The jury found the docks suffered $500 in damages. That's about $16,000 today, roughly. But here's a crucial finding. The court acknowledged the crew acted with good judgment and prudent seamanship. They did the right thing to save their ship.
Okay, so they acted properly, faced an emergency, but still caused damage. What was the core legal issue the court had to decide?
The issue boils down to this. Is a defendant who deliberately and prudently saves their own valuable property, the ship, by keeping it tied to someone else's property, the dock, during a crazy storm, still legally required to pay for the damage caused to that other person's property?
Even though the action itself was necessary and prudent?
Exactly.
What rule did the court apply to answer that?
They applied that core principle of private necessity we just discussed, basically. If an actor wisely and carefully uses someone else's property to save their own more valuable property, they're responsible to the owner for the damage they inflict.
So the privilege to use the dock doesn't mean you get to damage it for free.
Precisely. Use is privileged. Damage requires payment.
Now, this is where it gets really interesting for me. What was the court's analysis? How do they justify holding the ship owner liable when the crew did everything right and there was this massive storm? Why wasn't it just dismissed as an unavoidable act of God?
The act of God argument. The court tackled that head on. Their reasoning turned on this idea of control.
Control. But they couldn't control the storm.
They couldn't control the storm, no. But the court said the injury to the dock was not an unavoidable accident. It was, in fact, within the defendant's control.
How? Explain that.
Think about it. The storm itself was the act of God. But the damage happened because the crew made a series of deliberate choices. They chose to keep the ship tied up. They chose to replace the lines again and again.
So it wasn't passive, it was active preservation.
Exactly. It was a calculated decision. They were essentially weighing the cost, risk destroying a very expensive ship versus causing $500 damage to the dock. They chose the latter. The court saw this continuous replacing of lines not just as defense against the storm, but as an active appropriation of the dock's structure.
Wow, okay. So they viewed it like the ship owner was using the dock as a shield, sacrificing the dock to save the ship.
That's a great way to put it. They appropriated the dock's integrity for their own benefit. It was a volitional act. The court is saying, look, necessity gives you the privilege to make that choice, sure, but the law also says if you make that choice, you pay the bill.
It's a fairness argument, then. The party who benefits from the action pays the cost, not the innocent bystander whose property got damaged.
That's the policy heart of it. The loss falls on the one who actively used the other's property for their own preservation.
Okay, that clarifies the $500 payment. It's not a punishment, it's compensation for the property used and damaged. So the conclusion was?
The court upheld the lower court's decision. The ship owner was liable for the $500. Why? Because under private necessity, the privilege to act comes bundled with the duty to pay for the resulting harm.
The court used some analogies to really drive this home. Let's talk about the starving man analogy. How does that illustrate this point about justification versus payment?
Right, the starving man. It's a classic hypo. Imagine someone is genuinely starving, near death. They take a loaf of bread from a bakery to survive. Merely, we might say their action was justified by the extreme necessity. Maybe it doesn't even count as criminal theft in that context. But
they still owe the baker for the bread.
Exactly. Once they're able, they still have a civil obligation to pay the value of the bread. Necessity justifies the taking in the moment, but it doesn't erase the economic debt. It separates the moral or even criminal aspect from the civil liability to compensate.
That's a powerful distinction. So let's apply that logic. Imagine if the rental crew needed a stronger line and they saw a valuable cable just lying there on the plaintiff's dock.
Yeah.
They take it, use it to secure the ship during the storm. What happens then?
Same result as the dock damage. The court was very clear on this point. Even if the necessity was overwhelming, absolutely life or death for the ship, the owner of that cable could still sue and recover its full value.
So necessity gives you permission to use it, but not to take it for free.
Never for free under private necessity. It reinforces that strict liability for compensation attaches to the privileged act.
Okay, so Vincent firmly establishes the duty to pay. But what about the other side of this, the actual right to be there in the first place? How do related cases like Kloof v. Putnam and Depu v. Fletow establish that the property owner actually has to let you use their property in an emergency?
Good point. They fit together perfectly. Kloof v. Putnam, which came just slightly before Vincent, dealt with exactly that initial entry. a sloop caught in a storm moored to a private island dock without permission.
Just like Vincent, but focused on the trespass aspect.
Right. And Plouffe held that because of the storm, the sloop owner was not trespassing. The necessity created a privilege to be there. But the crucial part, the island owner's caretaker untied the sloop, casting it adrift.
And it was damaged, people got hurt.
Yes, and the island owner was held liable for interfering with that privileged entry. Plouffe says the property owner cannot kick you out when necessity requires you to be there.
So you have a right to temporary sanctuary, so to speak.
You do. And Depuis v. Flatau reinforces this from a slightly different angle. A guest becomes seriously ill during a visit. The homeowner can't just throw him out into a blizzard. Once someone is lawfully on your property and an emergency arises, you have certain duties regarding their safety.
So if we put it all together, Plouffe and Depew say the property owner must allow the necessary intrusion or use. They can't interfere.
Correct.
And then Vincent comes along and says, okay, you have the right to be there, but if you damage the property while you're exercising that right for your own benefit, you have to pay for it.
That's the complete picture. Plouffe grants the shield against trespass. Vincent attaches the invoice for damages caused during that privileged stay. It protects both sides. The person in peril gets safety. The property owner gets compensation.
All right, this is incredibly helpful. Let's try to boil this all down into something really actionable for, someone facing this on an exam or trying to analyze a real-world scenario. What's the step-by-step diagnostic checklist we should use for issue spotting necessity?
Okay, absolutely. We can create a solid, mandatory 4-step framework for tackling any necessity problem.
Lay out the full diagnostic checklist for necessity.
Here it is.
Identify the trigger. First off, was there a genuine emergency? An uncontrollable event, imminent danger, a major storm, something compelling the action. If the actor could have easily avoided the situation, necessity probably won't fly.
Okay, genuine emergency first.
Step 2. Determine the scope. Was the action taken actually necessary to prevent a substantially greater harm? And, importantly, was the conduct reasonable under the circumstances? Think back to Vincent. The crew's actions were deemed prudent. If they'd done something reckless, the analysis might change.
Prudence and proportionality. Got it.
Step 3. Classify the necessity. This is crucial. Who benefits? Is the action primarily for the good of the community or the public? That points to public necessity, which usually means an absolute defense, no compensation owed by the actor. Or is the benefit mainly for the actor's own private interests, their life, their property? If yes, that's private necessity. And if it's private necessity, you proceed to the final step.
Step 4, the big one.
Step 4, analyze privilege versus liability, the Vincent rule. This is where you apply the dual finding. First, the privilege. Because of the necessity, the actor had the right to be there or do the act. They're not liable for trespass itself, as Plouffe established. The property owner can't legally stop them or kick them out.
So, privilege to act.
But second, the liability. If the actor, while exercising that private necessity privilege, deliberately and directly causes damage, like the Reynolds crew actively keeping the ship against the dock, they remain strictly liable to pay compensation for that specific damage. The necessity justifies the action, but it absolutely does not excuse the damage without payment when the benefit is private.
That's a fantastic framework. Trigger, scope, classification, and then privilege versus liability under Vincent.
That's the way to break it down.
What a really fascinating deep dive. It's amazing how the law tries to balance these fundamental rights protecting your own stuff versus not damaging someone else's. And the bottom line seems to be, at least for private necessity, the price you pay for saving your own property is compensating the innocent party whose property you had to use or damage.
Absolutely. We really untacked Vincent, where the defendant's ship used the plaintiff's dock as a tool for its own salvation. But remember, the court specifically mentioned this wasn't a situation where the dock itself was somehow attacking or menacing the ship, requiring destruction and self-defense.
Right, the dock was passive.
Exactly. Which leaves us with a really interesting question to ponder, doesn't it? What happens to that duty to compensate if the tables were turned? What if the necessity involved destroying the plaintiff's property precisely because that property itself posed the immediate threat? Imagine, say, the dock was collapsing and about to crush the ship. If the crew had to destroy part of the collapsing dock to save the Reynolds, would they still owe compensation? Does the duty change when the necessary action is essentially self-defense against the plaintiff's property?
That's a different scenario entirely.
It is. Something to think about.